This is
Make It Plain.
MIP
With Masamela Matfumo.
Mark Thompson.
Make it plain.
Get woke.
Ladies and gentlemen, we have joining us today a very important conversation on a very important subject with a very important attorney and activist. He is the vice president of the Atlanta NAACP, Attorney Gerald Griggs. Brother Griggs, how are you today, man?
I'm doing great, Mark. How you doing?
Just fine. Always a pleasure to talk to you and hear your voice. I'm guilty of the same thing most other people are these days. We put all of our eggs in the basket of the Senate, and to no one's surprise, Manchin and Sinema sold us out. The popular belief is that only this Senate legislation could protect us from these suppression laws that have popped up in these 19 states and possibly restore aspects of the Voting Rights Act that were lost to the Supreme Court in 2013. So everybody's like, what do we do next? There have even been conversations around what Biden can do through executive order, and the consensus has been that he can do nothing. But you are here to enlighten us and change our minds about that, right?
Absolutely. One thing that people fail to realize is that in 2013 in the Supreme Court that dealt with Shelby County versus Holder, they were talking about the preclearance clause of the Voting Rights Act of 1965. It did not gut the entire Voting Rights Act. So when it comes to protecting people's right to vote on the basis of race or color, the 13th, 14th, and 15th Amendment, as well as the Voting Rights Act of 1965, are very much still in effect and are good law. I mean, we even saw that as recently as 2019 in the Bogornovich matter that came before the Supreme Court. Even in that case, they said that Section 2 was still good law. It just didn't apply in that case because there was no discriminatory effect. So the president, under our Constitution, has the power to enforce the law. The legislative branch has the power to make the law. Well, they've already made a law dealing with this, and that's the Voting Rights Act. Section 2 and Section 3, as well as Title 52 of the U.S. Code, speak directly to what the president can do. The president can authorize the Attorney General to file lawsuits against the 19 states that are pushing back and taking us back on voting rights. Now, of course, they don't have to pre-clear it with the Justice Department, but once it takes effect and it has a discriminatory effect based on race or color, they can sue to have federal monitors. They can sue to get injunctions to make sure those laws don't go into effect or are struck down as they are unconstitutional. So we are not in a place where we don't have tools in our tool belt or quivers in our holster for our arrows. We have plenty of things that we can do, and we have to call on the president to do those things. He signed an executive order, which was, for lack of a better term, fluff early on. But he can sign an executive order that has teeth, that orders the full weight and power of the Justice Department to go after these states. They've already filed a lawsuit in Georgia against Senate Bill 202 and in Texas against the bill there, which was similar to 202, but they need to file them in all 17 other states. And we need to take this battle from the streets and from the halls of Congress into the third co-equal branch, which is the judiciary, to push back on these this encroachment on our rights.
So in the suits that they filed, Gerald, in Georgia and in Texas, they filed those without an executive order, correct?
Absolutely.
So really, the Justice Department could do the same thing in the 17 other states without an executive order if it wanted to, right?
It can, but considering that President Biden made certain promises to the voters who got him the presidency, he needs to take proactive action to order the Justice Department. Because as you know, he's the chief executive. The Justice Department is a part of the executive branch. He can order them to be the chief lawyers for the country and to proactively go after these states to send a message to the rest of the country that voting rights are our top priority. You know, I was listening to several shows where they were talking about all the speeches that Biden has given on other topics, 60 or so on COVID, which is understandable, 50 or so on Build Back Better, but only 2 on voting rights, especially down here in Georgia where I am. I was present at the Clark Atlanta speech. And I think that, it's time, instead of speaking, to give action. And again, I'm taking this position as a civil rights attorney. This has no affiliation with the NAACP's official position. This is my position as an attorney who's practiced in this area. There are steps that can be taken.
So now let's just game this out, knowing how they operate. You're saying an executive order pretty much instructing the Justice Department to take action, correct?
Yes.
Now, in this moment of everything else has been going on, what do we do if the White House says, well, we want the Justice Department to act independently. We don't want to tell the Justice Department what they do. I mean, that's kind of the game they run these days.
Yeah, and we would remind the President of the United States that South Carolina delivered him the nomination and Georgia delivered him the presidency as well as the Senate. And the main issues that we were talking about were George Floyd, justice and policing, and protecting our voting rights. This is a existential threat to democracy.
Right.
We need proactive action. You have the power to order the Justice Department to act. It's codified in Title 52, which is Title 52, 10301 through 05. So I understand what the political position might be, but the legal position is different. You need to take legal action. It took strength and fortitude for Lyndon Baines Johnson to push through the Voting Rights Act. It's incumbent on this president to make sure that it's enforced.
More MIP after this message. And now that I'm thinking about that, going back to Lyndon Baines Johnson, is there not precedent for, because you talk about some other things, and we'll get to those, just other things in terms of what can actually be taking place at some of these polling sites. Is there not precedent, Gerald, for a president sending federal marshals into a state? Because if I remember, it wasn't the Attorney General that did that, or the Attorney General would do that at the request of the president. But I mean, can a president do that? Say, we're going to send, if these lawsuits don't go the way they should go, can a president send marshals, so to speak, to polling places to make sure people are not denied the right to vote?
Absolutely. And that's what the Voting Rights Act allows. It allows poll monitors or poll watchers to be placed there. That's part of what it guarantees, to make sure that the right to the franchise is not dissuaded and pushed back. So this president has that power. He has the absolute power that's been given to him by Congress, which is given to him in the Voting Rights Act. He also, as the chief executive officer under the Constitution, is charged with making sure the laws are faithfully discharged. So I would argue, yes, it's possible. It's been done before. It was done in the civil rights era. It needs to be done now in the social justice era. Yeah.
And we might need to stress that, because I know that's what they're going to say. Well, Merrick Garland, we don't want to interfere, especially coming off of another president who tried to manipulate the Justice Department. But you're absolutely right. This is different. What do you say to those? And there's another very prominent journalist with a podcast who basically has devoted her podcast to Merrick Garland's inaction on a number of issues. So what do you say to those who say that Merrick Garland isn't really taking this on as assertively as he should be?
I would say that, as respectfully as I know how, I'm hopeful with the possibility that the Justice Department is moving in a different direction than it was under AG Barr and under the Attorney General Sessions. But we have to do more. And so I would call upon him to do more. I'm hopeful with some of the appointments that have been made. Kristen Clark is an excellent civil rights attorney, and I'm looking forward to her work in the Justice Department. But we have to do more, and you have to push the envelope, and you have to make sure that you use the law. The law is there. So I hear a lot of the political conversation and the debates. I'm not a politician. I'm not a pundit. I'm an attorney. And I see what the law can do. I see the precedent there. And I'm hopeful that they will listen to this particular angle and take all appropriate action. I believe all action should be on the table, from marches in the streets and primarying individuals like Manchin and Sinema for what they did with voting rights. But being from Georgia, this is the birthplace of civil rights. John Lewis put his life on the line. Dr. King was martyred because of many of these issues. And so we have to take up that mantle and push back as strongly as we know how, because as Helen Butler has so eloquently said, who is the chief executive of the People's Agenda, the organization started by Joseph Lowry, this is our Selma moment. And so we don't want to, disrespect the history of our ancestors, and we don't want to pass off a worse off world to our descendants. So I think all available measures should be used. This is one of them.
I want to touch on several points you made in a memo you drafted. Things the administration can do under current law. One, the power to provide, you mentioned this, federal monitors, federal observers. They can do that. Seems to me that wouldn't be a heavy lift. You also write the power to suspend. They have the use of tests or devices which deny or abridge the right to vote. Expound on that, if you would.
Well, we always talk about literacy tests and poll taxes and counting bubbles in the bar of soap. Those are the tools that they used in the past to disenfranchise voters, particularly African Americans. Today, we're talking about voter purges. We're talking about closing of precincts. We're talking about removing individuals from local election boards. We're talking about exact match, where you have to have exact signature matches and things like that. Those are tests or schemes designed to limit access to the ballot. And I believe under the Voting Rights Act and the rules promulgated under it, you can suspend the use of those things through litigation by the Justice Department and an injunction by the courts. It allows for that to happen before the discriminatory effect of the law. So I think that we have to use all those available tools. Those were just some of the things that I was able to glean from reading the law. And my hope is that other people will read Title 52 on elections and look at the things that it provides for us to be able to do, and stop having the conversation that, all the Voting Rights Act was gutted and there's nothing that we can do. Pre-clearance was gutted. The other tools available in our tool belt are not.
More MIP after this message. And one other area, the power to prevent state officials from certain prohibited actions, folks, which might include, this is from under 52 U.S. Code, Section 10307. All the citations are here. Power to prevent state officials from certain prohibited actions, such as A, failure or refusal to permit casting or tabulation of vote, B, intimidation, threats or coercion, and paragraph E, voting more than once. These are all things at the power. But again, Gerald, I know you mentioned lawsuits. If this is law on the code, see, if you or I do something that's against the law in the code, they're not going to sue us. They're going to come pick us up. Exactly. So they don't go to court. And the risk in court, obviously, these days is that Mitch McConnell packed the courts. That's why we need to, and he got rid of filibuster to do that, even though they won't get rid of filibuster to stop this stuff. So then why couldn't Merrick Garland and Vanita Gupta and Kristen Clark literally send marshals down there and observers and see y'all doing this? You in handcuffs. I mean, maybe that's why you and I ain't the attorney general, but I mean, isn't that the way we would do it?
I mean, I don't know if I would go that far without, signaling the ability for governors and secretary of states to get on the right side of this. But I do believe that federal law provides that they can do all of those things, and it is well settled federal law. So when you have situations like the governor in Florida saying he's going to issue a private militia that's going to be the election police, that sounds like Bull Connor and George Wallace all over again. And clearly, federal law allows for punishment of states who are under the states' rights banner violating federal law. I mean, there's a supremacy clause, which has been around for over 100 years or more than 100 years, that says federal law trumps state law. So while we're having these debates, people need to understand this stuff's been settled. And so we need to use the tools that settle the debate once and for all. And I believe that the lawyers you just named are able and embodied individuals who follow the law. And my hope is they will use the law to make sure it protects people that look like me and you to having access to the franchise.
I would also just say, in terms of giving them an opportunity to get on the right side, I mean, you know, you listen to the JFK tapes, the RFK tapes, the LBJ tapes, they would give them the chance to do it by calling them on the phone. If you don't do A, the federal marshals are coming down there to do B. So you're right. But I mean, give them a signal. And maybe we're at that moment again. Folks claim that we're in a civil war. I mean, we're going to wait for some other people to fire the first shot. And see, frankly, Biden is in a box because our voters, his voters, and I mean, this is political, and I know you don't really get into that, but morale is down. People like you didn't deliver the protections you said you would. So if I'm president, well, I want people to see that I'm trying, and then challenge these states, send these people down there, and if they want to go to court, then that's on them. Let them show that they refuse to uphold what the Voting Rights Act says. Like, one more question. You've written this memo. What's next? I mean, I think this is a very serious conversation. I don't think enough people are having it. You are the only person I know who is really articulating this in this very specific and legal way as an attorney. How are you transmitting this? Is this a memo you are sending the White House, or are you and a group of attorneys going to organize this in? I mean, they need to get this and hear it from us and respond to it and let us know what they're going to do.
Yeah, absolutely. And, you know, this was just an idea that I came up with after watching the failure in the Senate. And so I just started researching the law, and then I started writing, you know, to make sure people understood what the law actually says. And of course, researching the constitutional law there and the Supreme Court decisions. And then I started transmitting it to civil rights activists. I gave it to Jesse Jackson. I will give it to higher leadership in the NAACP. And my hope is that other lawyers will join me. But if necessary, I will write a letter directly to the White House that we need to do this. And so, you know, as one of the activists that was outside in Georgia for 30 days before the passage of SB 202, which is Jim Crow 2.0, we have put our bodies on the line, and we will continue to do so. I look forward to joining Reverend Jackson in West Virginia, and of course, traveling back to Selma on March the 8th or 7th, and then April the 4th. But more mass action will happen, and we will continue to elevate the call. I will join with my brothers and sisters at Black Voters Matter, with Latasha and Cliff and Protect the Vote GA and the People's Agenda and Georgia Stand Up and the Black Women's Roundtable. All the people, particularly the Black women that have been putting their bodies on the line, we will stand with them, Tamika Mallory and Until Freedom and all of them, because this is our Selma moment. So I will transmit this document as high and as far as I possibly can to give them the ammunition I believe is available under the law to make sure we protect our right to vote.
Gerald, did you put this document on your website for the public to read it yet, or are you going to do that?
No, I have not. I will probably put it in a graphic form and put it on my website. It's clearly on my social media. I just tweeted out the actual sections of the Voting Rights Act that are still good law. Right. So I will get this document to everyone. But what I'm asking right now, because this is not about me, this is about the rights of the people. I want as many lawyers to look at it, and I want as many civil rights organizations and activists to transmit it to their body, to let the people know that we should not be discouraged in this moment. We have the strength and power of our ancestors, but the education they told us to get to make sure we push back in this moment. This is not 1865. It's not 1965. We are not 3/5 of a person. We have the 13th, 14th, 15th Amendment. We have the Voting Rights Act of 65. We have the Civil Rights Act of 64. We have all of these provisions that protect us, and we have access to the federal courts, because even though many of the courts have been packed, they still have to follow the law, and this is black letter law.
Y'all, that's why I'm not president, and this is me talking, not Gerald, because I would federalize the National Guard in these 19 states, and there would be no funny business. in these places, because there is precedent for that. And I know folk don't want to do that. And I would dare SCOTUS to come down on the wrong side of history when it comes to that. I mean, this might be just what it takes, and I don't think that's impolite. I don't think that's violent. I mean, that's what the law is there for. And we're owed that. Remember now, there were troops during Reconstruction to enforce the 15th Amendment. So it's not like this is America. This, as the brother says, Donald Glover, this is America. So troops were necessary then. Troops may be necessary now. At Attorney Griggs, you can read more about it on his social media and see it on his site later. Attorney Gerald Griggs, he's the vice president of Atlanta NAACP, but he's speaking in his capacity as an attorney. I know you're going to be talking to the NAACP National about this and others. I'm going to share it with others because this is something we need to seriously think about. As I said, many of us think there's nothing he can do, but there actually is something, according to Attorney Griggs, and I concur. Thank you for joining us on Make It Plain, brother.
I appreciate you, brother. Thank you.
Thanks for getting woke and listening to Make It Plain. Please remember to listen, like, and wherever you get your podcasts, please give the show a 5-star rating. And please do spread the word. Let's all continue to pray for each other during this pandemic and this police-demic. If all hearts and minds are clear, it has been made plain.